Hold on.
Good morning, everyone. Welcome to the webinar for Employers of Ontario Certified Teachers. Thank you for joining us this morning. As you would have seen, you would have come in on mute, and we do ask you to stay on mute and with your camera off throughout the presentation. We will have breaks throughout the presentation to prompt for questions. So if you do have any questions, please do put them in the chat, and we will have time for Q&A at the end of the session. With that being said, I will now pass it on to Linda to start the presentation.
Good morning. My name is Linda Lacroix, and I'm the Director of Investigations and Hearings at the Ontario College of Teachers. I wanted to take this opportunity to thank you for joining us this morning. We'll be discussing changes to the Ontario College of Teachers Act that gives the college's investigation committee, this is our screening committee for all complaints, a relatively new power to conduct medical inquiries where a member may have a fitness to practice issue. We will also discuss changes to the Act that require members to make self-reports to the college regarding certain criminal matters, a refresher on employers' duty to report, including obligations as they relate to fitness to practice matters on the part of the members, and finally, an update on the college's therapy and counseling program. I would like to introduce our presenters for today. We have Patrick Winter, our Senior Intake Officer, Evelyn Liu, Intake Coordinator, Janice Duggan, Manager of Investigations, Jeff Steinberg, Investigator, Bernadette Best, Investigator and Investigations Team Lead. College staff will stop the presentation between topics to answer any questions that you may have. They will also be available at the end of today's webinar to answer further questions. In addition, the information presented today will also be available on the college's website. So let's get started.
Hello, welcome everyone. Here you will see a list of the topics we will be speaking on today. We are beginning today's presentation with some slides regarding relatively recent changes to the Act that have given the Investigation Committee the authority to conduct medical inquiries regarding members who may have a fitness to practice issue. As of February 1st, 2021, the Act was amended and the Investigation Committee, the college's screening committee, was given new authority to make medical inquiries regarding a member who may have a fitness to practice issue. We will now outline how this process works.
To begin, when the college receives a complaint from an employer or a member of the public, the information is reviewed by a college investigator in conjunction with the manager of investigations or the senior investigator. If the information received indicates that there may be a fitness to practice issue, the matter will be taken to the college's investigation committee for its review and consideration. This slide sets out the factors that the college will evaluate in order to determine if the matter is a fitness to practice issue that may warrant the investigation committee making medical inquiries.
Under this new power, when the investigation committee reviews information relating to a member and they believe that the member may be incapacitated, they shall make inquiries regarding the member's health. This is the first step in the inquiries process. This new authority is set out in section 26(4.5) of the Act. The threshold to make these inquiries is very low, only requiring that the investigation committee believe that the member may be incapacitated.
Bernadette, what is the object of the exercise?
The object of the medical inquiry exercise is to resolve fitness matters at the investigation committee stage so that capacity matters can be more efficiently resolved. Prior to the change to the Act, the only way to resolve capacity issues was to send the matter to the Fitness to Practice Committee for a hearing. If the Fitness to Practice Committee determined that the member was currently suffering from a physical or mental condition or disorder, such that they are unfit to carry out their professional responsibilities, the panel may, among other things, direct that the member's certificate should be made subject to terms, conditions, or limitations. This slide sets out the legislative provision.
We often get questions from employers who are wary of providing confidential or private information regarding a member to the college. Pursuant to Section 47 of the Act, the college is entitled to receive that information, which is vital in medical inquiry files. Section 47(1) of the Act permits the college to request personal information, including medical information, about members as defined under provincial and municipal freedom of information legislation. Information relating to the education or the medical, psychiatric, psychological, criminal, or employment history of the individual, or quote, information relating to the financial transactions in which the individual has been involved, close quote. Therefore, if you have medical, psychiatric, or psychological reports relating to the concerns which prompted you to notify the college, these must be disclosed as part of your duty to report. The next slide will set out the applicable privacy legislation.
Jeff, before we get to the next slide, what steps does the college take to protect such information?
Well, first, under Section 48(1) of the Act, the college is required to keep such personal information confidential and not communicate the information to any other person, subject to certain exceptions, including the administration of the Act. When panels of the investigation committee write their decision and reasons, particularly in public complaints, sensitive personal information, including medical information that relates to a member, is referred to in a generalized manner so as not to disclose the particulars of the information. For example, if a member or an employer provided medical information that was particularly sensitive, that information would be referred to in a general manner.
The Ontario College of Teachers Act specifies that the college can require employers to send personal information to the college as defined in MFIPA and FIPA. These two privacy acts define personal information as including information relating to the medical, psychiatric, or psychological history of the individual. As noted earlier, this information is particularly important when either making a report to the college regarding a member's fitness to practice or when providing information relating to medical inquiries. We're going to pause here and break for a few questions. So if you have any questions about any of the information so far, please type them in the chat.
There are no questions at this time.
Under the new medical inquiries process, if, after reviewing the information, the investigation committee believes that a member may be incapacitated, it directs the assigned investigator to make inquiries about the member. This is where the employer comes into the process. As part of those inquiries, the investigator will write to the member's employer asking for any additional information regarding the member's health. The investigator will also make the same inquiry of the member, or if they're represented by their counsel.
And what happens after the inquiries are made? When the information from the member and the employer is received, the same investigation committee that directed the inquiry reviews all the information received. After reviewing all the information, the investigation committee has to determine if it has reasonable and probable grounds to believe that the member is incapacitated. Reasonable and probable grounds is defined as more than a mere suspicion. If the investigation committee does not have reasonable and probable grounds to believe that the member is incapacitated, the inquiry's process is at an end and the regular investigation process will continue. If the investigation committee has reasonable and probable grounds to believe the member is incapacitated, the investigation committee can still refer the matter to the Fitness to Practice Committee under Section 26(5)(a) of the Act, or require the member to submit to physical or mental examinations.
The physical and/or mental examinations will be conducted by an independent health professional specified by the investigation committee. The college bears the expense of the independent medical examination. Section 26(4.7) of the Act sets out the investigation committee's authority regarding the medical assessment.
If the member does not agree to the medical assessment, the investigation committee may make an order directing the registrar to suspend the member's certificate. This authority is set out in Section 26(4.7)(b) of the Act. This direction is subject to the member being given notice of the investigation committee's intention and being given the opportunity to make written submissions as it is set out in the next slide.
Section 26(4.10) of the Act sets out the legislative requirement regarding notice and written submissions. And Regulation 616/20 provides the member at least 14 days to make written submissions as to why that order should not be made.
If the member agrees to the medical assessment, the member is provided dates that the independent medical assessor is available. After the assessment, the health professional prepares a report. The report is shared with the investigation committee, the member, and/or the member's counsel or representative. The report will outline whether or not the member is incapacitated, the extent of the incapacity, and the prognosis for recovery, which may include compliance with medical treatment.
If no capacity issues are identified, the capacity inquiry is closed and a decision is sent to the member or member's counsel. The investigation committee will then make a determination regarding the appropriate disposition of the file from its other legislative authority. If capacity issues are identified, the member or member council and college staff will negotiate an undertaking that would include appropriate terms, conditions, or limitations to place on the member's certificate.
Generally, at a fitness to practice hearing, the parties have negotiated appropriate terms, conditions, or limitations, and have reached an agreement that is presented to a fitness to practice panel for consideration. With the investigation committee's medical inquiries process, the appropriate terms, conditions, or limitations can now also be negotiated at the investigation committee stage. However, because the investigation committee is not an adjudicative body, the investigation committee would only be in a position to adopt an agreement that both the member and the college have agreed is appropriate.
After the terms, limitations, and conditions have been negotiated, the investigation committee can adopt the terms, limitations, and conditions, or as noted earlier, reject the agreement. If the investigation committee rejects the agreement, or if the parties cannot agree on what agreement to propose, the investigation committee would refer the matter to the Fitness to Practice Committee for it to adjudicate the appropriate outcome. And we're going to pause here again for questions. So again, if you have questions, please type them in the chat.
I'm seeing no questions.
All right, thank you very much. So we are now going to move on to a new topic, switching gears a little bit, to some recent amendments to the Ontario College of Teachers Act regarding duties of college members to self-report. Now, this slide right now is going to outline relatively new legislation regarding a member's duty to self-report in relation to certain criminal matters in general. Bill 229 amended the Ontario College of Teachers Act to include new reporting obligations for college members for offenses, charges, as well as bail conditions and other restrictions. These reporting obligations took effect on December 8th, 2020, and failure by members to comply with these reporting obligations may be considered an act of professional misconduct. Again, on this slide, you will see the reporting obligations listed here if a member has been charged with an offense. When self-reporting, the member must include, among other things, the charge, when the charge was laid, as well as the location of the court in which the charge was laid. All bail conditions and release conditions must be included in the report, as well as the status of any proceedings. It is important that you as the employer continue to report criminal charges and convictions, as the employer does still have a duty to report these charges and outcomes under the Act. And as you can imagine, some members may not fulfill their obligation to self-report charges or convictions. Aside from fulfilling your reporting obligations, it is important that you make these reports because the college is mandated under the Act to post criminal charges as well as bail and release conditions that restrict a member's eligibility to teach, and the college also must report convictions that are relevant to a member's certification. So the college's mandate, as you know, is to govern the profession in the public interest and to protect students. Posting a member's criminal charges, applicable bail conditions, and convictions helps the college to fulfill its mandate by alerting the public to members who may pose a risk to students.
Thank you, Patrick. The next few slides will set out the statutory framework which governs your reporting obligations to the college, and this is a review of what has been provided in previous webinars. Your employer duties include an ongoing obligation to provide documentation as well as information to the college within a specified time frame. Fun fact, in a typical year, the college receives about 400 employer reports under Section 43.2 and 43.3 of the Act. I'm going to direct your attention to the slides. Section 43.2 of the Act says that if you as the employer terminate, suspend, or restrict the duties of college member for reasons of professional misconduct, then you must notify the college in writing within 30 days. And you must report this even if the member resigns while under investigation or while you're compiling evidence. Now, we all know what constitutes a termination or suspension of a member, but it may be less clear on what constitutes a restriction of duty. So here are some examples of what a restriction of duty could include. Number one, removing a member from an occasional teachers list, an administrative transfer of a member to another school for disciplinary reasons, as well as blocking a member from teaching specific grades or courses, etc. Section 43.3 is pretty self-explanatory. If an employee or former employee, please note this language, is charged with or convicted of a criminal offense involving sexual conduct and minors, or an offense that in the opinion of the employer indicates that students may be at risk of harm or injury, then the matter again must be reported to the college within that 30-day time frame. Please note that this section is written in such a way that you as the employer must report members to the college if you become aware of these charges and convictions, even if the member no longer works for you. So this applies to former employees as well. Section 43.3 continues to say that if a member has engaged in conduct or taken action that in your opinion as the employer should be reviewed by a committee of the college, then you should submit a report. This is what we call a catch-all provision, where if you're in doubt, then please report it to the college. In addition, we would like to remind you that you are obligated to provide a copy of your notification letter to the member at the same time you notify the college. We've also been asked in the past whether we notify employers of public complaints. So under the Act, the college is only required to report the outcome of investigations to you. But in most cases where matters are fully investigated, we will be requesting information from you, and in doing so, you'll inevitably become aware of public complaints against members at a much earlier stage of the process. We're continuing to Section 277.4 of the Education Act, which triggers the employer's duty to report in relation to teacher performance appraisals, or TPAs. If you terminate a member's employment following an unsatisfactory TPA, then you must submit a complaint to the college. This again applies if the member resigns while on review status during the TPA process as well. Now, what should an initial employer report include? What we're looking for here are some important pieces of information, including number one, the name and college registration number of the member, a summary of event that led to the report. I'm going to circle back to this point later. The specifics of disciplinary action taken by the employer. Again, we wanted to stress the importance of providing sufficient detail in that initial employer report. I'm going to focus a little bit on the second bullet point, summary of event that led to the report. What we're looking for here is enough information so that we're able to make that initial recommendation as to whether a college investigation is necessary. We're looking for a description of event or events that led to the employer discipline and not just a general form letter. I'll provide a brief example. Instead of saying John Smith was suspended for 3 days due to inappropriate language, what we're looking for is a more detailed description of what exactly the member said, what was the comment made by the member, and that way it helps us making that initial recommendation. If necessary, we can follow up, and we will follow up with employers to get more information, but ideally some more detail at the beginning would be really helpful and greatly appreciated. How to submit a report to the college. Now more than ever, we will highly encourage employers to submit your employer report as well as any additional documentation and information via email at ih@oct.ca. Due to COVID-19, we currently do have a limited mail capacity, so we will highly encourage employers to submit everything via email at ih@oct.ca. A friendly reminder that if you report by email, there is no need to submit a hard copy of the same report via mail. If you would like to ensure that we have received your employer report, you can ask in the reporting email that college staff acknowledge receipt of your email, and we're happy to do so.
All right, thanks very much, Evelyn. We would like to remind you now that the college now has a fillable employer report form. The college's investigations and hearings department routinely looks for ways to make the reporting process easier and more efficient for employers of Ontario certified teachers. The new fillable employer report form provides an outline of all information that's required by the college when an employer submits a report. It can be completed and submitted to the college along with any necessary supporting documentation at ih@oct.ca whenever a report is required. Please note, however, that it's not necessary to use this new fillable form. It's being provided for your convenience should you wish to incorporate it into your existing reporting procedures. However, if you are currently submitting reports to the college using a different method, that is totally fine as well. If you have any questions about the form, or if you have not yet received it and would like a copy, please feel free to contact the college's intake unit at ih@oct.ca, and we would be glad to assist you.
Okay, we will now turn our minds to what the college requires in relation to section 43.2 and 43.3 reports under the Act. If the matter moves forward to investigations, as many of you know, you will receive a letter and a checklist asking for further information relating to the report and also the member's discipline and conduct history with the employer. We will speak more about the latter point in a few moments. You are required under the Act to provide the college with all documentation relating to your report within 30 days of submitting the report to the college. We suggest you start assembling the information immediately following your report to the college in order to meet the 30-day deadline. When there are delays in providing the information with no notice or explanation for the delay provided to the college, or general unresponsiveness, the Director of Investigations and Hearings or the registrar may contact the employer's Director of Education or the equivalent at a non-publicly funded school. So let's now do a quick review of the documents required by the college following an employer report. As noted, the college requires information and documentation pertaining to a member's previous disciplinary history and conduct issues. Why do we ask for that information? Well, sometimes when employers are reviewing a member's history, they discover that a matter that should have been reported to the college was not. For example, a member was suspended, but through oversight, the matter was not reported at the time. This is an opportunity to alert the college to that prior suspension. Sometimes a member's prior conduct issue did not lead to a mandatory reporting obligation, but in light of the current report, it may represent a pattern of conduct. The college is attempting to get the complete picture regarding the member so that the investigation committee can make a fully informed decision.
Jeff, when the college asks for information regarding a member, what would that information typically include?
Well, good question, Bernadette. We are seeking all underlying investigation information and documentation, such as principal, vice principal, investigation notes, witness statements, including those of any alleged victim, investigation findings and reports, disciplinary letters, and all relevant correspondence, including email, text, or social media messages. Each case, of course, will yield different information that was gathered during an investigation, depending on what the allegations were. But what I just listed is typically found in all investigations. The college also requires the member's current employment status and the dates of changes to their status. For example, has the member retired from the board or employer? Has the member gone on a medical leave? The names, addresses, and contact information for school and board staff who were involved in the investigation, and those of any affected students and student witnesses are also required. Please do not send redacted documents. If a matter is referred to investigations, the assigned investigator will redact the documents as appropriate before they are disclosed to the member who is the subject of the investigation. If redacted documents are sent, this will lead to the investigator sending a follow-up inquiry seeking the unredacted materials. For TPA matters, the college will require a copy of all of the summative reports for the member and any materials relating to the TPA process, such as the principal's observation notes and improvement plans.
I just want to add that you may wish to go to the employers area portal on the college website that provides further information concerning employer obligations. Again, most of you are probably aware of the checklist that you receive when the college writes to ask you for further information regarding a report. The checklist sets out what documentation the college is requesting from you. If you are not familiar with the checklist, please send us a note in the chat and we'll get back to you with this information.
And I'm just going to add, and this does relate to a question we received prior to the webinar. When we send the checklist, we do ask for all information relating to a member's conduct with the employer. And when we make that request, we're looking for the same type of information that we would want to see in a current report. So any underlying materials that related to the investigation of an older matter that may not have been reported to the college. The question we received was, does the checklist apply to the 3-year rule? And by the 3-year rule, I took that to mean that as a term of a labor employment issue at the employer, a member's letter of discipline or reprimand, something that was not a restriction of duties would be removed from their personnel file. And the short answer to that is yes, we would still like to see that letter and any information that's related to that investigation.
Thanks, Janice. Please note that any information you send to the college as a result of the checklist or as requested by the investigator must also be provided to the member within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply. If you have questions or concerns about sending unredacted materials to the member who's the subject of a report, you should consult legal counsel for advice. Once you've provided all the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the Act requires that such information be provided within 15 days of the employer receiving the second request. It is important and appreciated if employers advise if they will be unable to meet a deadline. There may be a good reason to request an extension, and the college is open to considering such requests. Please contact Janice, the Manager of Investigations, if you require an extension. Janice's contact information will be set out later in the presentation. As noted earlier, the college wants to keep the lines of communication open, so please do contact us if a problem arises with the timelines.
Okay, I'm now going to address some of the most common questions the college receives regarding our requests for information. In relation to the slide on the screen, the answer is yes to all bullet points. Please send audio and video materials, all handwritten notes, and if not legible, please provide a typed copy as well, and copies of settlement agreements. So in terms of audio and video materials, these must be provided. For example, this would include video recordings of a hallway incident or a video received from a student in relation to an allegation. In terms of notes, the college is asked about notes and what is required. So the college requires any notes, handwritten or typed, relating to the complaint, such as opportunity to respond meetings, interview notes, principal notes, vice principal notes, etc. Prior to commencing an interview, please be sure to include for each set of notes the author and title of the person taking the notes, the full name and title of the individuals present at the meeting or interview, the date, month, day, and year, start and end time of the meeting or interview, the location of the meeting or interview, the subject matter of the interview, and please make it clear what incident or incidents you are discussing. Please also identify the date of each incident in question. This would include the month, day, and year. If the reported conduct occurred over a long time frame, please identify the date as best you can, or include a broader time period, such as in or about the spring of 2021 or in or about March 2021. And as mentioned, we would appreciate type notes, or if that is not possible, please ensure legibility.
We would like to take a moment now to discuss documents which are sent to us in the form of screenshots. We often receive screenshots of electronic exchanges, for example, email threads, text message, and social media messages with information missing. Please be sure to identify how the screenshot came into your possession. For example, on October 1st, 2021, a student named Jane Doe showed school principal text messages she had exchanged with her teacher, John Smith. On October 2nd, 2021, school principal Nancy Jones took pictures of the screen of Jane Doe's phone, which displayed these text messages. Okay, and our next point is the settlement agreements. So regarding settlement agreements, these will often contain a provision indicating that the agreement can be disclosed if required by law. For example, a legislative requirement, such as that contained in the Ontario College of Teachers Act, is a law that requires this information. You cannot enter into an agreement, including minutes of settlement, with a member which includes an undertaking that is contrary to your reporting obligations under the Act. For example, you cannot agree not to report a matter to the college that is required under the Act. Also, you cannot agree not to continue to provide information to the college due to the ongoing reporting obligations. Your reporting obligations under the Act cannot be contracted out. So any section of a settlement that agrees to remove an employer's reporting obligations to the college is invalid. While you as the employer may have settled a matter with a member by having, for example, the member resign from their employment, this does not end the employer's obligations to the college. Please do not write to the college to advise us that a matter has settled and request that the college close its file. The college will not do so. Under the Act, the college has a public interest mandate that must be enforced.
Okay, in the previous slide, we touched on what to send. This slide addresses what not to send. So please do not send redacted documents, password protected documents, or illegible documents. Looking at the first bullet point, redacted documents. When the college requests documents from employers, it's essential that we receive the documents in their truest form. That is to say, without redactions. Oftentimes, we receive employer disclosure packages with student names, ages, and grade levels and contact information redacted. We also request similar contact information about the parents of the student witnesses, if the student witnesses are minors. I know I'm repeating myself, but please only send unredacted documents. We require this information for the purpose of our investigations. Additionally, the college sometimes receives employer disclosure packages without the student witness contact information. Please ensure it is included in your disclosure package. There may be a reason for contacting the students during the college investigation, so that information is important. Now, some employers have voiced concerns regarding confidentiality regarding this type of information. We want to assure you that this information remains confidential. As noted earlier in the presentation, contact information is redacted from disclosure made to the member. Please be advised that the college does not disclose student witness and/or student victim contact information. However, we do disclose student witness and alleged victim names. Why do we do that?
Thanks, Jeff. We do that because the college has a disclosure obligation to the member during the investigation process. The member is entitled to have all relevant information in order to provide a response to the complaint. When conducting an employer investigation, please do not give members or witnesses assurances of confidentiality. You will be required to provide the college all interview notes and contact information as part of your statutory duty to provide information to the college. As noted, the college is obligated to disclose all information to the member during the course of its investigation. Therefore, any assurances of anonymity should not be given to an alleged victim or witness. Without that information, a member may be able to argue that he or she could not fully respond to the complaint. And our next point is password protected documents. The college has received questions about sending password protected documents. Please do not send password protected documents to the college. The college email system is secure and confidential. And also, as stated earlier, the college does not require hard copy of employer packages. The college's strong preference is to receive an electronic version of the employer materials. And also, please ensure that the documents that are sent are clear and legible. And please note here again that the timelines specified in the Act remain the same regardless of your academic calendar or closure period.
Bernadette, what if there's an ongoing grievance or arbitration for the member?
The legislation does not allow the college to delay an investigation when there is an ongoing grievance or arbitration. The employer discipline process and the college's investigation process are two separate processes. While we may follow up with you to determine the status of a grievance, this is just to ensure that all the up-to-date information has been gathered for the investigation committee.
Thank you, Bernadette. We're going to turn to some of the frequently asked questions relating to the employer's duty to report. Number one, do I have to report when an employee goes on the medical leave of absence? So in and of itself, the answer is no. An employer's reporting obligation under Section 43 of the Act, as stated earlier, are triggered due to a suspension, restriction of duties, or termination of a member's employment for reasons relating to professional misconduct. Where a member goes on medical leave of absence in the course of an investigation, and you're uncertain whether the member's conduct constitutes professional misconduct, then we would encourage you to report the matter to the college. I saw some questions in the chat about this second question. Do I have to submit a report to the college when the member is assigned to home pending the outcome of investigation by the employer? So it's not necessary to report that a member has been assigned home pending an investigation. However, once the investigation concludes, and if the member faces a disciplinary restriction of duty, as we covered earlier, then the matter must be reported to the college at that time. If an employee goes on a medical leave during a board or school investigation regarding their conduct, am I required to report this to the college? As we stated earlier, yes, in this case, we would encourage you to submit that report as it may have relevance to how the investigation committee choose to deal with the member.
Okay, and turning to the last question on the slide, what is the employer's reporting obligation when a third-party investigator is hired to conduct an investigation of a member? So the college receives employer notifications where a third-party investigator has conducted the investigation. And in some of those situations, the employer has entered into an agreement with the third-party investigator that permits the investigator to have ownership of its underlying investigation product. So while the employer will provide the third-party investigator's final report, it is not able to provide the underlying investigation materials, for example, interview notes, because of the agreement signed with the investigator.
Thanks very much. So moving on to our final topic, I'd like to briefly talk about the college's therapy and counseling funding program. Now, we did mention this at last year's webinar, but there has been a change and we would like to draw your attention to it. So for those of you who are unfamiliar, the college has introduced a program to help defray the costs of therapy and counseling borne by students who allege having been sexually abused by teachers, involved in child pornography, or a prescribed sexual act. If a student has been sexually abused or was the victim of a prohibited act involving child pornography by a member of the college, help is available. Victims, parents, guardians, and siblings can apply for funding to help pay for some of the costs of therapy and counseling. The Ontario College of Teachers will make funding available to help cover victims' costs for therapy and counseling, and approximately $17,000 to $18,000 can be claimed. The amount is equivalent to what the Ontario Health Insurance Plan would pay for 200 half-hour sessions of individual outpatient psychotherapy with a psychiatrist. It is important to note that the college had previously communicated that this program was available only to victims in cases where the alleged conduct had occurred after the implementation of the program on January 1st, 2020. This requirement has since been removed, and victims are encouraged to apply for the program regardless of when the alleged conduct occurred.
Hello. To support you moving forward, we will provide you with a copy of the slides and a link to the recording of this webinar via email in the coming weeks. We will also include a link to an online survey in this email. Please feel free to complete the survey, as your feedback is important to us and it helps assist us in future webinars. I have Patrick and Janice here with us to answer some of your questions if there are any left to answer.
I think I'll address the question that I think employers ask, and it was touched on in the presentation, but that is the issue of having to fulfill your obligation under the Act to copy the member on what you send to the college. And I just want to reiterate what was said in the presentation is that is the section of the Act. You are obligated to do it, but I think it's important for the employer, if you have concerns about what you're disclosing to the member, to seek legal advice on that issue. The college can't give you legal advice. It can just point out your statutory obligation. And then I think you need to take it up with counsel as to any concerns you have about what you might be disclosing to the member. Because I understand the concern expressed in the email question, and that's probably not a great answer for you, but it's the only answer that we can provide.
Thank you, Janice.
Okay, so we do have some questions in the chat. I'll start with the first one. It's from Janet. What are the common limitations and concerns that you see come up?
Janice, did you want to try that one? I'm not sure.
Janet does pipe up and help me there. Does it mean what are the most common types of complaints or reports that we receive?
It was actually from the start of the presentation, a little bit back before we started the second section. And you were talking about for the medical assessments, we had provided information through, and then is for the capacity of the members. So I just wondered if you could give us, I guess, a couple of examples around when someone, their capacity of their membership is being questioned.
I think Patrick can probably speak to this as well, but I think that the most common type of capacity report that we receive, it relates to some type of addiction and or a mental health comorbid condition. I think it's fair to say, I don't have the actual numbers, but I think it's fair to say that that's probably the most common type of report that we see with respect to fitness to practice.
Janice, would you be able to comment on the types of conditions that we typically would see on a certificate?
Sorry, maybe I misunderstood the question altogether. No. Okay, yeah, the types of conditions that you would see on a member certificate would be, for example, if there was an addiction issue, you would have ongoing counseling or therapy, maybe even drug testing, urine testing, that sort of thing. When it's a fitness to practice matter, though, as you know, if it's a fitness to practice hearing, those are held in private, or as lawyers like to say, in camera. They're not open to the public. The decisions are not published. The notation that goes on the register for the public to see is that the member's certificate is subject to terms, conditions, or limitations, but that's the extent of the information available to the public when it arises at a fitness to practice hearing. The same will be true if the investigation committee also adopts an undertaking that sets out terms, conditions, or limitations. That's the most information available to the public will be that the member certificate is is subject to terms, conditions, or limitations. And I think that's, in each case will be different because they're fact driven in the capacity matters. But the object is not only to protect the public and students from somebody who's not fit to practice, but also to assist the member to return to the practice. That's the point of the terms, conditions, or limitations. Hopefully that addresses the question.
Thank you. Yes.
Okay, great. Our next question is from Elise. Please define restrict, even if we send them home with pay.
Great, so thank you. I'll field that one. I think it was mentioned toward the end of the presentation. If an individual is sent home with pay pending the outcome of an investigation, the college does not consider that to be a circumstance where a report would be required at that time. Section 43.2 subsection 6 of the Ontario College of Teachers Act outlines what is considered a restriction of duty. So it includes things like, of course, a suspension or termination of employment, suspension for disciplinary reasons, not pending the outcome of an investigation. Termination of employment obviously would be included there, as well as things like restrictions on the age of the students, grades or subject that a member may teach. Restriction on eligibility to teach without supervision would be included in that. There's a longer list here that would be included, but essentially it's any sort of restriction that's done for disciplinary reasons. So if it's at the point at which something is being investigated, at that point the restriction of duties, even if the person is assigned to home or assigned to non-teaching duties, that restriction would not be considered for disciplinary reasons at that point.
Thank you. You might have answered the next question as well for Jennifer. She asked, does a suspension pending an investigation trigger the duty to report under section 43.2? Or do you report only after your investigation is complete and a discipline that suspends or restricts is the outcome?
Again, yeah, it's the same thing. We only require it once the disciplinary restriction has been issued. That being said, if there is a matter which is clearly obvious that is going to eventually lead to a disciplinary restriction, and you do feel that it's important to notify the college right away, there's no obligation that you wait. We would keep a file open ourselves pending any further information that we needed in order to make a decision on whether we were to move forward with our own investigation. But if it's an extremely serious matter and you think it should be reported to the college, you can do it right away. We'll gladly accept that.
And Patrick, I was just wondering if you could give a few examples of what you would consider to be that type of serious allegation.
Sure. If somebody's been sent home pending an investigation into inappropriate sexual conduct with a student, even if it's not a situation where it arises to the level of criminal charges being laid, and you are confident that it is something that is going to lead to the restriction of duties, please feel free to send that in as soon as you are confident doing so or are comfortable doing so. There is no need to wait for what could potentially be a lengthy investigation to conclude before notifying us. There are certain circumstances where the college may need to take action with respect to having the member sign an undertaking not to teach, or an individual's certificate may even be subject to an interim suspension for extremely serious allegations. And if that's the case, then please move it forward as soon as you're comfortable doing so.
Thank you. And then this next one kind of piggybacks on that as well. Tracy asks, would this include single-day suspensions for items that have been investigated or only for long-term suspensions?
Yes, it does include any length of time for a suspension or any restriction of duties, no matter how short the suspension is or how minor the restriction is, must be reported.
Okay. Jennifer asks, the IPC recommends against sending personal information by email unless high standards of security are taken, including security in transit and at rest. What protections has the OCT taken to ensure that the IPC's requirements of electronic security are met if reports are done via email?
Unless anyone wants to chime in with a particularly great answer at the moment, I would like to take that to our IT department to get you a thorough answer that we can send to you by email afterwards. It's a great question, and I know that it is something that our IT department takes extremely seriously, given that it's not my area of expertise, and I don't want to speak for the rest of our team too much, but I don't think any of us are really experts in that field. So we'll get back to you with a better answer than that as soon as possible.
Okay. Elise asks, previous conduct history outside of the 3-year rule?
Sorry, yes. Yes, as far back as you can go. It may be that it may be, for example, I'm just thinking of one file like off the top of my head where the board actually did realize that something hadn't been reported from almost 20 years ago, and they still had a file on it, and they provided it. And it's really up to then for the investigation committee to determine what to do with particularly old matters. But again, I think as we pointed out in the presentation, particularly where it might not have been something that had to be reported to the college because the members' duties weren't restricted, but that earlier matter or matters may form a pattern that relates to the matter that actually did trigger the reporting obligation. So yes, even beyond the 3-year rule, we would like to see that information.
Okay, great. And then Patrick, just so you know, Jennifer had added to the chat, thank you. I look forward to your email regarding the IT security. Sure,
and we'll send that to everybody as well, not just to Jennifer.
Okay. Great.
Will it be safe, Patrick? I think there was one question that was in the email that Elise had sent. Elise, I think that we tried to address this question on at Tuesday's presentation, but it was the issue with respect to guardian or parental consent being involved at the board level when something's being investigated and you've decided that you need to report something to the college, but there may be parental or guardian involvement where they say they don't want that done. Linda is a former superintendent, former principal. We had a discussion about that this morning. And the college's view is that you need to conduct your investigations as you would normally. And then, as Linda points out, the investigation committee, it's a screening committee. It reviews documents and other types of information gathered. It's not a hearing. Nobody's required to attend. I mean, Jeff did point out that it may be that in the course of an investigation, a student will have to be contacted, but that's more on the rare side than the usual side. So at this point, the investigation committee is just reviewing the information and making a determination about how to dispose of the complaint. Most complaints do not get referred to the discipline committee. Most complaints are dealt with by the investigation committee, and the outcome is it comes from there. So there will be no actual involvement of students. If it does go to discipline, then a parent could say, if the student is a minor, that they don't want them involved in the discipline process, and that would be their right to do at that point. But I think the college's position is that if you have information and you've interviewed a student, and you have a mandate to provide that that information to the college. With respect to issues about how you deal with students and the interview process, and if you involve parents or guardians at the board level, that is really something that you will have to take up with legal counsel for the board. We cannot give advice about how to conduct investigations. And I hope that addresses the questions raised in the email.
Absolutely. Great. Our next question is from Michelle. She says, you have said that we must provide the member with all of the information we send to the college. Are you now saying that we can redact student contact information when we send this to the member?
No, I think what the point of our presentation was that we redact that information when we send it to the member. The conundrum for you as employers is you have to give us unredacted information. We recognize that presents a challenge for the employers. And again, I think just to reiterate the points in the presentation, you need to seek legal advice about anything that you would be doing with respect to how you disclose to the member. Unfortunately, we can't give you that advice. I do think it's important for you to contact counsel though, whether you have a board lawyer or you need to retain someone in order to talk about how you deal with disclosure to the member. I mean, our position is that we have to have it unredacted. And I recognize it presents a problem for the employers, but I think you really need to seek legal advice about how to handle the issue of disclosure to the member.
Thank you. I think that also answers the next two questions. They were asking something similar about what they should be giving the member. And so I think you answered that as well. We have one more question. What is the threshold for OCT for deciding if a member is incompetent? Oh, hold on. And how may this differ from the employer's threshold for termination?
Do you mean the question addressed like through the TPA process? Is that if we get some clarification on that?
Thomas, I don't know if you want to clarify.
Yes, it was the TPA process, yeah.
Okay, I think the short answer is you have to assess teachers' performance based on the competencies and in the TPA process. I can't really comment on, because this at our level, at the investigation committee level, they're going to determine whether or not the process has been conducted properly, because there's quite the process involved under the Education Act and the regulation, and then they're going to determine whether or not the allegations relate to incompetence, which they do, and whether there's sufficient evidence to refer that. And so each case will be handled differently. And then whether or not somebody's found to be incompetent is a decision made by the discipline committee. And I can't really comment on that because that's the whole adjudicative process. So I can't really comment on how it is that the discipline committee arrives at its conclusions about competence versus how the board would, a school principal or vice principal assessing a teacher's performance would arrive at that they failed the TPA process.
Okay, thank you. And then we did have one more come in from Andrea. Can we provide student contact information on a separate page and not provide that sheet to the member?
I know you can tell from the number of questions that this is something that really bothers the employers, and I get that. The short answer is I think you need to look at the section of the Act, and off the top of my head, I'm not going to be able to quote it, but it says any information provided to the college you have to provide to the member. Again, all I can tell you is that you need to seek legal advice about that, fulfilling that obligation, because we're not in a position to give advice on that issue.
Thank you. That is all that I'm seeing in the chat right now.
I just wanted to make sure, I'm just going to go back to the email that was forwarded, just make sure that we covered off all the questions in the emails.
I think that in one way or the other, all of these questions have been addressed.
Yeah, I would agree with Patrick. I think that's correct.
Excellent. Go ahead, Bernadette. You're muted.
Sorry, I just want to thank our participants again for attending. And if you have any more questions following the webinar, please feel free to contact Janice Duggan or Patrick Winter, and their contact information you'll see on the screen.
I also want to thank everyone for joining us today, and thanks to the presenters for all this information and time taking to put this together. So wishing everyone a wonderful afternoon.